Hey gun people, this is a good little document. I'll put a link to the PDF in the description, so if you want to download it or print it or share it. It mainly applies to Texas, but it's the same philosophy in most states. There's a few things in here that are different than other states, so you need to know your own states, but most deadly force situations have the same philosophy. So let's go through. And this is put out by Texas Law Shield. I'm not getting any cut or any deal from them. Because I'm retired law enforcement, I get a deal. I think I pay $125 a year for free legal advice, legal representation for civil and criminal if I'm involved in a shooting or any use of force where I have to use force against somebody and I get sued or arrested. So to me, it's a good peace of mind. Again, I'm not promoting or saying there's nothing better, but so in this, it kind of goes through what if I'm charged with a crime, talks about Class B, Class C misdemeanors, and the different gun charges that you can get in Texas. And then it goes into felonies. So if you use a gun, you could get manslaughter, murder, capital murder, criminal negligence, aggravated assault, or deadly conduct. And these are the terms: first degree 5 to 99, second degree 2 to 20, third degree 2 to 10, state jail 108 days, 2 years in jail. So it kind of goes over that, and then it gets into the Castle Doctrine and some other stuff. This is an important part that everybody, and I always tell you, don't talk to the cops, and be careful what you say on 911, because it's always recorded, and 911's job is to get as much information as they can, so make your call quick. Location, what happened, your name. I think in here it kind of says maybe what you're wearing, but you know what? They know where you're calling from, they got your number, and they may try to call you back. Now, you may think, because if I call 911, I don't have any protections because I voluntarily called. Well, it's the same thing if you answer 911. If 911 calls me, they can ask me anything they want, because the court will see that as I had the opportunity either not to answer, or to hang up, or to not answer the questions once I did answer. So that will all be considered voluntary and will be used against you. So don't talk after the shooting. This is important. Talk to your lawyer. Inform the police that you have been a victim of crime. State you wish to mow. Saying you've been a victim is important, because the police will try and make you the aggressor, or the person you killed's family will try to make you the aggressor, or the left-wing media will make you the aggressor because you used a gun. So make sure you state, hey, I'm the victim here, and I wish to invoke my Fifth Amendment rights to remain silent. So, and I want to consult with an attorney. That will stop the questioning. And if it doesn't stop the questioning, any questions they ask you and you answer after you said this cannot be used against you. Now, obviously, you don't want to do this and then give a complete confession, or make up lies, or try to mess with the police, or be funny, because even though it can't be used against you, it can still lead them to something else. Or if you end up taking a stand and you say something contradictory, it can be brought on under an exception of, hey, we're going to bring this in to impeach the witness. And that's an exception to get in statements that would normally come in. So don't try to do a First Amendment audit, or be cool with the police and think you know everything after you shoot somebody in self-defense. Make no statement to anyone. This is a key point, because if you call your buddies, or if you call your mom or your family or your ex-cop or your buddy, they become witnesses, and when they try to get a case on you, they're going to subpoena your phone records, and they're going to see everyone that you called. And if you called somebody and you made a statement like, man, I know I shouldn't have done it, man, I shot him because it was, I knew I shouldn't, but I didn't like the guy, or I had a bad day, so I said, what the hell, I'd kill him. You say something like that to a friend, now they get your records and they call him in, and now he gets charged with perjury, or he folds on you, or he gets nervous and he doesn't want to go to jail for you for lying, so he tells the truth, and next thing you know, now you have statements out there that can not only impeach you, but that they can use against you, even though you invoked your rights. So don't talk to anybody about it, or be very careful who you talk to, and don't do it in public. Don't do it over the phone. And it's easy to say don't talk to anybody, but people are going to talk to somebody. If asked to accompany law enforcement, make no statements, do not make jokes or cute remarks, etc. Okay? Know your rights. Invoke your right to remain silent. So this is all good advice here. Then it goes down to the process in Texas now. When you get charged, there's the incident, law enforcement investigate, they'll give it to the DA. The DA will either say arrest him, we think we have probable cause, or they'll say, you know what, I'm going to give it to grand jury. If the grand jury says no bill, then you go free. If the grand jury says, hey, we think you did some things, then they put out a warrant on that. You can be arrested, then you have to post bail. Formal charging, bail, grand jury, whatever, it all goes back, and then it goes through motions, pre-trial, all that after you get charged, and then there's either a trial or conviction. Remember, in a trial, there's 3 ways that the jury can rule. They can find you guilty. That means everybody agreed you were guilty. Then you're guilty. There can be a mistrial. A mistrial means that 1 or more jurors said opposite of the rest of the jurors. So 1 juror said guilty, everyone else said not guilty, or 1 juror said not guilty and everyone else said guilty. You still get a mistrial no matter what the numbers are, unless they can all agree. The jury either agrees that you're guilty and you're guilty, or they all agree that you're not guilty, and then you get acquittal. If you get an acquittal, the government can't come after you again. You're free to go. If you get a mistrial, the government can refile and you can go through the process again. I think it's BS, but that's the way it is. Then once you're convicted, you go to sentencing. They get into legally justified, whether or not you're legally justified to commit. A general rule, it is illegal to shoot someone. So you just can't go shoot somebody unless it's done with a particular set of circumstances. Self-defense or defense of others. The law states that a person is excused from illegally, or the shooting is legally justified. What is deadly force? In Texas, deadly force is the law that defines a force that is intended or known by the actor, and they use that by the person doing the act, the victim or the criminal. The actor to cause, if you shoot someone, you're the actor. And the manner of which it is intended, use is capable of causing death or serious bodily injury. Firing a gun is considered deadly force. Okay? Kicking someone in the head, running over them with a car, anything that can cause serious bodily injury and or death is considered deadly force. And that's pretty much standard in most places. And bodily injury is physical pain, illness. Serious bodily injury is the substantial risk of death, disfigurement, loss of impairment, bodily functioning, or an organ or member. So serious bodily injury is serious. Let's see here. My name's Shirley. Quit calling me serious. Anyway, I digress. If you use deadly force, your contact measured by reasonable person standard. Now, when cops use deadly force, it's used by a reasonable cop standard. So, as a citizen, when you use it, it's used by a reasonable person standard, which isn't really fair, because if a person has police training or military training, most people on the jury will not have that training, and I think that should be an issue on whether or not you're being judged on a reasonable person standard, because the people on the jury don't have the training and experience that you have. They don't do it for cops. Why should they do it for us? Because government gets to make the rules, and us pesky tax-paying citizens have to abide by the rules. So anyway, reasonable belief, and was it immediately necessary? Now, I just did a video, and I don't know if I posted it yet or I'll post before or after this. California just changed their deadly force law to where instead of saying reasonable, they said it must be necessary. I don't think it changed a thing, but the libs are hollering that, look how great we are. We're trying to stop cops from shooting people. It ain't going to change a thing. Okay, deadly force. Using reasonable force standard. Would a reasonable person under the same or similar circumstances agree that deadly force was immediately necessary? So that's the reasonable force standard. When can you use? Is deadly force legally justified if you reasonably believe it is immediately necessary to prevent murder or someone else using deadly force, home invasion or carjacking, aggravated kidnapping, robbery or aggravated robbery, and sexual assault or aggravated sexual assault. So, according to Texas Penal Code 932, provides a person justified using deadly force when or to the degree the person reasonably believes deadly force is immediately necessary to protect themselves from the commission or attempted commission of those crimes, murder, aggravated, etc. Let's see. This is about the same thing. Again, you can print this out. 933 says you're justified using deadly force if you believe the intervention is immediately necessary to protect a third person. So you can use it on yourself. Again, I usually say deadly force is authorized to prevent serious bodily injury from yourself or others. So that's the way I describe it. Here's the way the Texas Penal Code describes it. About the same thing. You cannot shoot for trespassing. A lot of people think you can be shot in Texas for trespassing. Well, maybe you can at night. You have to justify it. Not deadly force to terminate a trespass on your property. But that's just a simple trespass. You can shoot them if it's at night and you think they're robbing or you have reason to believe they're robbing. If they commit an arson, a robbery, a burglary, aggravated burglary, theft during the nighttime, theft during the daytime, you can't shoot them. Theft at night, you can. Criminal mischief during the nighttime, during the daytime, you can't. So knowing 942 of the Penal Code on when you can shoot on your property, again, any of these things at daytime or nighttime, if you can justify that you were in immediate fear of serious bodily injury and or death, then you can shoot. So even if they're doing a theft at nighttime, if you can justify that you were in fear of your life, then you're not shooting because of the theft, you're shooting because you were in fear of your life. Statements matter and how you say it. That's why you shouldn't say it till after you talk to your attorney. Third-party property, you can do the same thing if somebody, if you're protecting a neighbor's property, as long as they say, I think they have to say they gave you permission to protect their property or they wanted you to do it. If they come out and go, I didn't want him to do it and I didn't ask him to do it, then you might have issues. So protecting someone else's property is iffy. You can claim a defense of necessity if your action was urgently or immediately necessary to avoid imminent harm and the action clearly outweighed. So this is for dogs or animals, protection against animals. Pretty much you can shoot most animals if you say you're in fear. Obviously, if you shoot someone's pet gerbil, you might have an issue that you were in fear of your life, but I think in Texas it'd probably be okay. The DA probably wouldn't prosecute. Texas law specifically allows deadly force against a dog or coyote who is attacking or has immediately attacked your livestock, fowl, or domestic animal. So if it attacks your cat or dog or your gerbil, you can go ahead and shoot a dog and coyote in Texas, no problem. The law allows for killing these other animals who are destroying crops or property. So that pretty much puts open season on them. All you got to do is say they dig a hole, they tore up your fruit tree, they tore up a tree, anything, you can pretty much shoot them too. And then if a circus comes to town, be sure keep an eye out for dangerous wild animals, because in this section it says dangerous wild animals. Well, everything in government has to be defined. What's a dangerous wild animal? Well, 822-101 of the Health and Safety Code says a dangerous animal is a lion, tiger, cougar, or leopard, whatever, chimpanzee, and several others. So know your animals if you're going to use that as a defense. Theft occurs when someone appropriates your property with the intent to deprive. Robbery occurs. Intentionally, knowingly, or recklessly cause you bodily injury. Intentionally or knowing threatens to cause you bodily injury. Okay, so that's robbery. And what I use for the definition of robbery and what they use in California where I learned it is robbery is the taking of property by the means of force or fear. And that pretty much describes this same thing. Again, most states may word it different, but they're usually on the same principle. Aggravated robbery exhibits a deadly weapon or causes serious bodily injury. So that's aggravated robbery. Burglary, according to this, burglary occurs when enters without consent and remains or conceals in any property or building with the intent to commit a felony, theft, or an assault. Now in Texas, they include an assault. In California, it's enters any building with the intent to commit a felony or theft. And that's why sometimes they'll charge burglary if you enter a department store and steal, and then when they arrest you for theft, if you don't have any money to pay for what you stole, they could make the case that you entered with the intent to steal because you entered a store with no money. So what other purpose would you be going in there? You weren't going in to buy anything because you didn't have any money. And that's how sometimes a theft of a business can turn into a burglary. Actually, when you enter, a building with the intent, you have to prove the intent that you entered with the intent, and not having money kind of proves your intent. Okay? Does the whole body have to enter? No, it doesn't. Any part of the body, according to Texas. So he sticks his finger through to unlock. If he sticks his hand on the door, he's entered. You can shoot him. The old thing, wait till he get inside. You got to wait till he get inside. If you shoot him, pull the body in. I mean, I've heard that so many times growing up in Texas. People are like, shoot him outside. The cop said drag him inside if you shoot him outside, so he's inside. Or just drag his arm or kick his arm inside through his threshold, whatever. I mean, if it's legit, it's probably going to be legit. The law of assault, intentionally, knowingly, bodily injury, physical contact, okay, aggravated assault, uses a gun, car, something. Duty to retreat, this is important. A lot of states are passing stand your ground. Okay, in California, there is no stand your ground, and there is a duty to retreat. You must try to retreat. Of course, it's liberal left. I always say the liberal left is not about freedoms. They're not about protecting people. They're about making people dependent on government. So in California, you have to run and wait for government to come save you. You cannot defend yourself. So the word stand your ground is not found in the Texas Penal Code. Stand your ground is a popular name for legal philosophy referred to has no duty to retreat. That's what Texas has. You do not have a duty to retreat. If you qualify under this statute, a prosecutor or law enforcement cannot argue that you had a reasonable escape route and that you should have fall back or retreated. In California, they do say you have a duty to retreat. In Texas, there is no duty to retreat. And again, stand your ground. Let's see. No retreat is legally necessary if. Now, here's the problems where people get caught. And it's usually trespassing. If you're asked to leave a place, you immediately become a trespasser, and now you don't get this protection to no retreat. So you only have no retreat is legally necessary if the following is met. Use of deadly force is justified. Okay, if you're justified, you don't have to retreat. You're good to go. If you have a legal right to be at the location where the deadly force. So if you trespass, break in, cross a fence, climb a fence, get in someone's car and shoot them, even though it's legally justified, if you don't have a legal right to be there, you lose the no retreat protection. Okay, you get the no retreat if you did not provoke the person against who the deadly force. So if you go, like I did a video on, I don't know if it was in Texas, the guys in the alley, they had a gun, they go, come on, I'll shoot you. If you come up here with that pipe, I'm going to hit you. If you hit me with that bat, I'm going to shoot you. They were provoking. In Texas, they could lose their no duty to retreat. That doesn't mean they will, but they could. And as long as you were not engaged in any criminal activity at the time of deadly force, which trespassing would be a criminal activity. So know that you have no duty to retreat if you're basically in compliance with the law. Castle doctrine. Castle doctrine means your house is your home, you can protect it. The words castle doctrine are not found in Texas Penal Code. Castle doctrine is a popular name for legal philosophy that every person has the king and queen of their own home and never has to flee their castle before using deadly force against an intruder. So basically, we have the castle doctrine, but it's not called the castle doctrine. And you can find that in 932 of the Texas Penal Code, or if you look up at whatever state you're in, most states have their penal code online and you can look it up. Okay, use force on a castle doctrine. If you think somebody's entering, if they enter your vehicle, the vehicle is covered under the castle doctrine. If somebody tries to carjack you or unlawfully enter your vehicle, you can shoot them just like they're entering your home. Important. In Texas law, a habitation is limited to the structure or vehicle that allows for overnight accommodations. Now, what is overnight accommodations? I can sleep in my truck, so it's got overnight accommodations to me. Therefore, other structures not attached, unattached sheds, barns, and balsas are not covered under the castle doctrine, although they may be covered elsewhere. And where it goes elsewhere, if somebody's stealing something from your unattached garage at night, you can shoot them because it's theft at night. So again, understanding the law isn't as simple as everybody wants to make it out to be. It's easy to say. That's why you shouldn't make a statement to police, because your lawyer is going to be able to ensure how you articulate what you say. Because if you say, I shot him in the shed because it was my house and it's under the castle doctrine, you will be wrong. Whereas your attorney would say, wait a minute, it wasn't your house, it's not covered in a castle doctrine, but you can shoot him because they were stealing from your boathouse at night. So therefore you are justified. But if you make that first statement that I did it under castle doctrine and you're wrong, you just make it harder to defend yourself, and you make it easier for the government to put their boot on your neck. Two independent legal systems. There's a criminal system and a civil system. Criminal system is the state versus you. Remember, in the criminal system, you have to have all 12 juries agree, and it is beyond a reasonable doubt and above a moral certainty. In the civil system, it's you against another person, and they only have to tip these scales one way or another. It's 49 to 51%. Whoever gets the 51% believable wins in a civil system. Now, in Texas, 8301 gives you protections against being civilly loaded. And I think this ought to be, you ought to protection anytime commits any crime against you, you're civilly not liable. I think Texas needs to get on the ball and enhance this. Of course, California doesn't give this protection, but if you have used deadly force, the law protects you from civil liability is contained in Texas Civil Practice and Remedies Code 83001. A defendant who uses deadly force that is justified under the penal code is immune from civil liability for personal injury and death that results from defendant's use of force. So if you kill somebody and it's legally, you can't be sued. Well, let me rephrase that. You can be sued, but you'll be able to claim immunity because of this section, and they won't win and it'll be dismissed. Let's see. Member law shields. All attorney fees for Texas Linfield are both for criminal and civil. So again, Texas Law Shield will provide you all the fees. And if you're law enforcement, they give you free expert witness. If you're not law enforcement, then you have to pay, I think, extra. Unless you pay more for that coverage, you would have to pay for expert witnesses. As a cop, if you get the law enforcement program, you do not have to pay for any experts, which is good. So in Texas, they kind of go over where you're legally authorized to carry a gun. Public places, yes, no, whether you have. Again, if you want to download this and read it, if you're not in Texas, really going to do it. Hospitals and nursing homes, you can carry a long gun or a handgun if you're a CHL holder. I did not know that. I thought hospitals were off limits, but according to this, it is. So I might have to check that out. I'm going to call Texas Law Shield and ask them about that, because I didn't think we could carry in a hospital. How to properly use this. What is Texas Law Shield? It goes into those guys. Good little article. Good things to understand in whatever state you're in. Know what the law is and how to protect yourself. Again, I'll put a link to this for Texas people. If you're not Texas, again, if you understand this concept, even in Texas, you'll probably be okay in your state, but it's better if you understand your state. Now, is it reasonable that if you travel a lot that you know every state's, every law's, every definition? No, it's not reasonable. And that would be a defense. It doesn't mean you won't get charged, but it can be used as a defense. So hopefully you get something out of this, and we'll end that there on when can you legally shoot in Texas. All right, we'll end that there.